Thanks for inviting me. I normally I don't like to make this a unidirectional kind of a lecture. So what I thought I'll do is I'll just maybe lay out the two or three main issues I want to flag for around 25 to 30 minutes, or even less, and the rest of the time we can have for discussion, so that it can be more interactive. So I thought I'll do it that way, and also, this is not a discussion so much about 370, because that's been discussed to death by now over the last 1 year. What the merits and the demerits are, I think everyone has a view on that by now, and so there's no real point in flogging a dead horse. But I think that what's important is that the manner in which the alteration was made to 370 was not just about 370 itself, but about some deeper constitutional issues that go beyond the specific constitutional relationship between the now the erstwhile state of Jammu and Kashmir and the Union of India. So what I want to do is actually address some of those broader constitutional points, because the manner in which the constitutional challenge is ultimately decided will affect a whole range of issues that will have a much more long-standing significance. So that's what I'll do. Before I start, like I did yesterday in another talk, I just want to express solidarity with Mr. Prashant Bhushan, who was subjected to, I think, what was a clear travesty of justice in a contempt of court case a couple of days ago. And as law students and as future members of the bar, I think it's important to engage with these kinds of issues around the functioning of the court and the bar, and just to stress that that the court is a very important political actor. It doesn't stand above the fray in any real sense, and its decisions, its non-decisions, its orders, its stays, all of it has an impact on how democracy progresses or regresses. So if you believe that the Supreme Court's decisions or the absence thereof is having a deleterious impact on democracy in the country, then to say that is everyone's right, and should not be subjected to punishment for that. So with that, I'll start. If you have a copy of the Constitution, you can open it, because it is slightly the discussion, at least in the beginning, is slightly technical. So if you open it up to, and if you don't have a copy of the Constitution, that's fine. We'll just we'll go through it slowly. So if you open it up to Article 370, which established the relationship, or still does, between Jammu and Kashmir and the Union of India. So basically, in sum, if you look at 370 subclause 1, subclause D, it says that effectively those provisions of the rest of the Constitution will apply to J&K, subject to such exceptions and modifications as the President may, by order, specify. So the basic arrangement was that there is a Constitution of J&K due to historical reasons, and parts of the Indian Constitution from time to time are made applicable to the state through presidential order. And the CO 272 that brought about the alteration of the special status of the state on 5th August last year was one such presidential order. Now, there's a proviso to this Article 370 subclause 1, subclause D, that reflected the fact that such changes would not be unilateral in nature. So they would be made with the concurrence or the consultation of the government of the state, depending upon the nature of the order. So the government of the state was involved in this decision-making process that would reflect which provisions of the Constitution and to what extent applied to the state of J&K. Now, the desirability or absence thereof of this arrangement is something that we're not concerned with here. We're not even concerned with whether it was right or wrong to bring about this change. What we are concerned with is the fact that at the time that CO 272 was passed, the assembly of J&K had been dissolved, and there was governor's rule in J&K. So the elected representatives of the state at that point of time literally did not exist. There was no such thing as the assembly. The assembly had been dissolved a year and a half earlier after the coalition government between the BJP and the PDP had collapsed. And for a year and a half, no elections were held, which is somewhat irregular, but not by those standards that are often applied in JNK, but it is somewhat irregular. So at the time at which this alteration happened, there was no government of the state that was an elected government. The governor, who was a central government appointee, was the individual who was literally the government of the state. And so both the president and the governor are obviously central government appointees. And so, in that sense, the alteration was unilateral because both functionaries take instructions from the same body, which is ostensibly the central cabinet. Even that is something that is contestable, and even that's something I'm not going to get into here. There are arguments and counter arguments on that issue. What I do want to get into, and this is the first of the two main points I will raise, is the nature of the change that was made. So what CO 272 does is that the alteration it makes is that it changes Article 370 via 367 and says that references to the government of the state will hereinafter be construed as references to the governor of Jammu and Kashmir. So it replaces the government with the governor. And secondly, Article 370, Clause 3, which effectively declared that no change could be made to these terms, that is, the relationship between J&K and the Union of India, except in accordance with the Constituent Assembly of J&K, which was a body that existed in the 1950s to frame J&K's constitution. You could not take a decision without the recommendation by the Constituent Assembly. So CO 272 replaces Constituent Assembly with the term Legislative Assembly. So it effectively downgrades the threshold that you require to effect that change. Right. Now, there are a whole host of arguments about whether this was right, wrong, so the right way, the wrong way, whether this was permissible in this manner or not. What I want to focus on is the fact that effectively at this time, in the state of J&K, Article 356 of the Constitution was enforced effectively, which is the fact that when the constitutional machinery in a state breaks down, then president's rule is declared, and that state is governed from the center. In Jammu and Kashmir, there is a more complex arrangement about president's rule and governor's rule, which we don't need to go into for the purposes of this discussion. So the first key question I want to pose is whether this kind of a change is permissible during president's rule. And the question I'm interested in is that if representative democracy is a basic feature of the Indian Constitution, as is evident in the constitutional text and as was recently held by the Supreme Court in the NCT of Delhi judgment, then at the point at which that representative assembly is dissolved or suspended and the rule is by a central government appointee who is not elected by the people of that state, at that time, is it permissible or is it possible to effect such a structural, permanent, and enduring change in the very composition of that state, which by definition the assembly cannot undo when it comes back to power, right? So on the one hand, right, when you have president's rule, obviously you need to have governance and administration. So the president will take decisions, will pass orders so that life can continue in that territory during that time. That is one kind of presidential action during president's rule. But the action you're concerned with here is something far more, very different and much more far reaching. It basically, while suspending the state's elected body, changes the very character of that body itself and the state, so that that becomes permanent and cannot be undone once president's rule is lifted. Because eventually you have to lift it. Eventually there have to be elections, because representative democracy is something our constitution is committed to as a matter of principle. Right? And so the argument, therefore, is that president's rule, by its very nature of being an exception to the normal circumstance of representative democracy and elected rule, carries within it certain implied limitations. And one of those implied limitations is that during that temporary period of president's rule, the central government cannot utilize that temporary character to effectuate a permanent change, because the temporary situation has to only allow for temporary changes, not something that you can't undo even after that temporary situation is over and the elected body comes back to power. If you see, for example, Article 357, Clause 2, that suggests something similar. So, for example, it says that, and this is it's about the extent of power during an emergency under 356. It says any law made in exercise of the power of the legislature of the state by parliament or the president or other authority as referred to relevant shall continue in force after the proclamation has ceased to operate until altered or repealed or amended by a competent legislature or other authority. So you can see that there is an implied idea in the Constitution that what happens under this kind of an emergency, the 356 style of an emergency, is something that can be altered or repealed or modified when the elected government comes back to power. But what has happened here is that the change is of a manner that has actually downgraded the very status of the assembly itself. So it can't come back and then repeal or amend that, because it no longer has the power to do that. It cannot come in and give itself that power once more. Right? And so the question, therefore, is that can you effectively degrade the status of the elected body in a state while the elected body itself was not functioning, and in a manner in which the elected body cannot then, when it comes back, undo or alter. If you've been following the controversy around ordinances, you can see something similar at work there. So ordinances are meant to be temporary decrees that the president issues that have the same force and effect of law, because at that time the parliament is not in session and you need to do something urgently and so on. Over the years, rule by ordinance has become effectively the default way of conducting governance, because it allows you to bypass parliament or the assemblies, as the case may be. And so in 2017, in a 7-judge bench of the Supreme Court placed limitations upon the ordinance making power and specifically said that the ordinance will not have force beyond its expiry date unless something that is literally irreversible has been done, like building a dike because a flood was coming, something of that kind. So you can see that there's this idea that where the Constitution departs from the rule of representative government and gives to the executive these temporary and emergency-oriented powers of legislation, be it ordinance-making power or be it the emergency power, then the Constitution also acknowledges that that's exceptional, and therefore the scope of that power must be interpreted in the most restrictive way possible, so that the exception does not become the rule and end up swallowing up the basic principle of representative democracy. So that's why this issue is important, because if the court holds that this was permissible and it was fine, then it is effectively holding is that there is quite literally no limitation upon what the president can do during president's rule. There is actually there is no constitutional check on his or her actions, subject to the ratification processes internal to 356 and other provisions. And that, according to me, would be a problematic conclusion, because it would elevate effectively the executive to a position somewhat above the constitution. It would effectively give the executive more or less unchecked powers to do anything that it wants during an emergency structurally. I'm not talking about fundamental rights here, because that's a whole different story. But structurally, to constitutional arrangements, the federal structure, and so on, it would mean that the power effectively is unchecked. And so I think that that's a deep structural point about the constitution. And this whole idea of the constitution placing an implied limitation upon the different constitutional actors, so that even in cases of emergency where one actor is given the task that other actors normally perform, there are still certain principles that operate to limit and check what can be done during that time. So that's going to be, like, I think, one issue that really goes much further and much beyond the whole argument around 370 itself, and speaks to a deeper issue of how much power does the executive have in our constitution. And this whole idea, and this has been written about in many other countries, about over the last 50 years there being a gradual shift where other deliberative bodies, representative bodies, are gradually ceding power to the executive, and the executive is becoming all powerful. The court's ruling on this point will determine to what extent that project goes forward or is stopped at this point. So I think that's something to look out for and to follow at whatever point the arguments resume. I want to contextualize this in a very interesting recent judgment of the UK Supreme Court in September of last year, called Miller versus the Prime Minister. Now, in Miller, the question before the UK Supreme Court was whether the power of the Prime Minister to prorogue the Parliament, so effectively suspend it, was unlimited in character. Now, the 11-judge bench of the UK Supreme Court noted that parliamentary accountability, that is, the accountability of the executive head to Parliament, was a fundamental constitutional principle under the Westminster system of democracy, which is also what we have. And so there were limits upon the executive's prorogation powers. And this is what the court said. I'll quote the paragraph 47. It is of some assistance to consider how the courts have dealt with situations where the exercise of a power conferred by statute, rather than one arising under the prerogative, was liable to affect the operation of a constitutional principle. The approach which they have adopted has concentrated on the effect of the exercise of power upon the operation of the relevant constitutional principle. Unless the terms of the statute indicate a contrary intention, the courts have set a limit to the lawful exercise of the power by holding that the extent to which the measure impedes or frustrates the operation of the relevant principle must have a reasonable justification. For the purposes of the present case, the relevant limit upon the power to prorogue can be expressed in this way. A decision to prorogue Parliament will be unlawful if the prorogation has the effect of frustrating or preventing, without reasonable justification, the ability of Parliament to carry out its constitutional functions and as the body responsible for the supervision of the executive. Now, I want to clarify and unpack this a bit. So what this means is the following. What this means is that you have two constitutional powers. One is the Prime Minister's power to prorogue Parliament. That is at the Prime Minister's discretion. And so then Parliament is suspended. So that's the Prime Minister's power under the Westminster Constitution. The other principle is the principle of parliamentary accountability. So Parliament checks the executive, and the executive is responsible to Parliament. When you prorogue Parliament, then the latter obviously cannot happen because the Parliament isn't in session. So what the UK Supreme Court said was that at the point at which your exercise as the Prime Minister of your prorogation powers is effectively frustrating Parliament's ability to hold executive to account, that is the point at which your prerogative powers end. So in this case, it was a 5-week long prorogation just before Brexit was going to happen. and the court found that there was no justification for seizing parliamentary functions at this time, given the importance of Brexit and the need for parliamentary accountability. But what the idea here is that within the constitution, often there are competing principles. So in this case, the two competing principles are president's rule, because sometimes you need to have president's rule in these states, whatever state it is, and representative democracy. So these are two principles which are in clash, because when the president is ruling, then you cannot have representative democracy. And the point at which the presidential power under president's rule is limited is the point at which representative democracy would be permanently frustrated. So, therefore, what the president can do during president's rule is administration, governance, and so on, because those are all temporary day-to-day measures. What the president is limited from doing is that kind of an alteration or a change that the representative body cannot then undo or modify, because then that would effectively destroy its own power as the source of legitimacy in a democratic state. So that's kind of what is at stake. These two really important principles are what's at stake in this particular argument. This whole idea of implied limitations is also present in the second main issue I want to consider, which is the downgrading of the state of J&K into two union territories through the J&K Reorganization Act of 2019. Now, again, everyone knows what the act did. It effectively bifurcated the state into two UTs, J&K and Ladakh, and then those UTs were to be governed in their own way. Now, first of all, it's important to note that that's never been done before. So there's always been a steady progression from UT status. In the 1950s, there were Part C and Part D states. There's been a gradual shift towards more representation and better representation, deeper federalism, and it's never really gone the other way. So in that sense, this is the first time that's happened. Now, for this, I will ask you once again to take up your constitutions if you have them. Article 3 is the core is the core constitutional provision here. Article 3 states that is titled Formation of New States and Alteration of Areas, Boundaries or Names of Existing States. It says Parliament may, by law, form a new state by separation of territory from any state, or by uniting two or more states or parts of states, or by uniting any territory to a part of any state, increase the area of any state, diminish the area of any state, alter the boundaries of any state, alter the name of any state. And there's some procedural conditions. And then the explanation, which is important, says that in this article, in clauses A to E, which is what I just read out, the state includes a union territory. So wherever there is the word state, you read the word union territory there. Now, this article is quite striking because it really shows you the extent to which the parliament has power over states. It can literally extend to destroying a state completely and erasing it, and all the state can do is kind of send recommendations. It has no veto power over that. So that's that's something I think is disturbing, but that's a discussion for another day. Now, if you read the text of this article carefully, and I'll leave you all to read that, and just try and at some point go through it line by line, you will find that even if you substitute union territory for state, there is no express power here that allows for degrading the state into a union territory. Now, of course, the counter argument there is that, well, if you can literally alter the boundaries of any union territory, form a new state by separating a territory from any states or parts of union territory. So if you keep substituting these two terms, the power is effectively unlimited, and so you actually can degrade a state into a union territory. And that's the counter argument. What that shows you is, in a manner of speaking, the wording of Article 3 does not dispose of the issue. So there is no express power to change a state to a UT. At the same time, the kind of power here seems to suggest that it at least flows from the article. So there is no linguistic clarity on whether it's allowed or not. The arguments on both sides, right? And here is where the issue of implied limitations once again becomes really important, because consider what the legitimate outcome of the argument that this the central parliament can do this would be. It would be that effectively it would be legally and constitutionally permissible to degrade every state in the union into a union territory, and thus turn India into a union of union territories, right? So only union territories will exist in India. So the power would extend to that, right? And that clearly shows that that would bring this into a clash with the constitutional principle of federalism, right? Because the federal structure assumes the existence of states. Article 1 of the Constitution, that's something that we normally never read because it's Article 1. It says, India, that is Bharat, shall be a union of states, and the states and the territory shall comprise of the territories of states and the union territories. Right? So the existence of states as entities is implicit in the federal structure of the Constitution, and federalism itself has been held to be a part of the basic structure, as all of you know. So then the question is that is it permissible to vest in Parliament a power that would legally enable it to convert India into a union of union territories without any states whatsoever? And again, notice this is not an issue about abuse of power. This is not that old kind of chestnut about a power is fine, its abuse is a different matter. We cannot strike down something just because it may be abused. This is not a question of abuse. This is actually a much deeper point. If you were to read into Article 3, the power of Parliament to degrade a state to a UT, then without any abuse whatsoever, completely legally and completely constitutionally, it would be possible for Parliament to do that to every state and for India to have only union territories. And that, of course, would then clash with Article 1 and the federal structure. So once again, you have the idea of implied limitations coming into play. And here, what that idea says is that the power of Parliament to alter, reshape, change the boundaries of states is limited by the federal principle that assumes the existence of states in India. And so the power cannot go beyond that. And therefore, the power cannot include the power to change a state into a UT, because then the logical implication of that would be that then the federal structure is compromised. Right? And so that is, I think, the second major, larger issue in this case, which goes far beyond 370. And it speaks to the question of federal structure and what does it mean when we say that India is a union of states, India is a federal democracy. So to sum up what I've said, and exactly half an hour in, so we can move to discussion, is that I think that there are two larger issues in this case. One is the idea of representative democracy, and what are the things you can do when you have suspended the representative body of a particular state during president's rule. The second is an issue of federal structure, and how does the federal structure limit the powers of the central parliament? Connecting these two issues is this fundamental constitutional concept of implied limitations. That is, that there are many constitutional principles that go into making a constitution, and when we interpret ambiguous text, when we interpret the constitution, we need to keep in mind that all these principles are given their due, and that we do not give any one body the power to effectively negate the other equally important principles, because every constitutional body gets its own power from the constitution. And so these principles therefore kind of mark the boundaries of what these different constitutional actors can do. So with that, I will stop, and I hope this was interesting and a little different from the debates around 370 that I'm sure, have been tired of hearing over the last 1 year. This was something a little different and a little more to do with constitutional structure, because we often tend to get really we tend to romanticize fundamental rights, and which is very important. And uh, what we often forget is that the most effective safeguard to individuals and individual rights is by a decentralization of power. So if any one body, when any one body holds all the power, that's when individual rights are most at threat. And constitutional structure is all about decentralizing, distributing that power, and having checks and balances upon that power through different bodies. And I think that the unilateral way in which 370 was altered, and the constitutional challenge to it, raises that question really fundamentally: that do we have a constitution that distributes power, that has these checks and balances, or do we have a constitution that allows for the centralization of all that power into one body? So with that, I'll stop and look forward to discussion, carrying on next 20 minutes or so.
So there is a question in a comment box.
Yeah.
If it's visible to you by Aryan Ahmed.
I can't see anything.
There is a comment box if you can see on
I
your
can I
screen.
can see it. I can see a comment box, but I can't.
Yeah.
Ah, okay. I see. Now I see. No, it was in the wrong thing. Okay.
So the first question is by Aryan Ahmed.
Yeah. Okay, right. There's no real safeguard to prevent states from being made into UTs. I mean, yeah. So this is the whole point about implied limitations, right? The, they are the subject of judicial interpretation. So you need like a court that is sensitive to understanding that, and that's exactly why I brought into the discussion the Miller case, in the UK, because up till the Miller case, it was believed that the power of prorogation was unlimited, because the UK is an unwritten constitution, right? So they don't actually have any written any well. That's controversial, but there is no one document that sets out the powers and functions of the different bodies. So the belief was that there was no actual check upon the prerogative powers of the prime minister. As the executive head, the prime minister decides when to call the parliament and when not. But then the UK Supreme Court, drawing upon this whole idea that there are principles in the constitution that need to be drawn out, held that they do exist implied limitations. Uh, Keshananda Bharti is a good example, although technically in that case, a majority rejected implied limitations in amendments. That, of course, again is controversial because of Justice Khanna's judgment that is a little confusing. But again, there the basic structure is something that was derived from the constitution. It wasn't something that was expressly there. So I think that in the constitution as it presently stands, that's where the safeguard lies. In the long run, I do think we need to really reconsider uh, the unbalanced character of our federal structure, because to me it's really unheard of that the parliament can just erase a state without even the consent of that state, and that really isn't federalism. So we need to, I think, reconsider at a deeper level, what do we understand by federalism, why do we need it, where its value lies, and so on.
So one more question, Aniket is asking that how far you believe that the government is still that this move was to garner security of India and sustainability.
I think that the evidence on that is on the record, and everyone can make up their own minds. My opinion on that has no more value than anybody else's opinion. I think that like everyone's in a position to look at the record after August 5th and decide for themselves to what extent they agree or disagree with that logic.
So if audience have any further question, you can list that in comment box. Okay, so So I think we should end here because there are no further questions by the audience, the participant.
I mean, if you
We
have any questions that come to you, you can always ask elsewhere. You can email me or ask on social media or someplace. We can carry the discussion onwards. That's fine.
So if participants email you, that is fine with you.
Sorry.
If participants email
Yeah,
you,
I may not be able to reply immediately, but I will try to reply eventually.
okay, all right.
Yeah, I see there are a couple of more questions here.
Yeah, yeah. There is one by Aisha Zaidi, if you
Yeah,
can
okay.
see.
What are the implications if there are elections held? Will this order be placed for the assembly now? Well, that's the whole problem, right? So the assembly, when the assembly comes back to power, it comes back as the assembly of a UT. It comes back as the assembly of a UT where the governor is the individual who is now in charge of his or her consent being taken for any further changes to 370. And so the returned assembly is a diminished assembly. Its powers have been altered in its absence, and it now under the new framework is operating with reduced powers. So it can't make it can't do anything to the order. I'm trying to think of an appropriate analogy for this. Yeah, I mean, like, what's a good example that would kind of make this point clear? And it's something like you have and it is that very basically you have two parties A and B to a contract, and you need you need a consent of A and B uh, to make any changes, right? What you do is and this is again this is a snapshot example. You put a gun to B's head and make them sign a change to the contract that stops them from that basically makes their future consent irrelevant. So while you have a gun to B's head, B has to sign a new contract that does not require their further consent for any further alterations to it. Then you remove the gun from B's head and say, now you do whatever you want, you're free. But this new contract does not allow B to like make any changes to it. And so while there was a gun to B's head, um, B's own status was downgraded, so that when the gun was removed, they could no longer have the power to bring their status back up. So that's kind of like what had happened. They replaced the gun to the head with the dissolution of the assembly, but it wasn't in existence. So then, obviously, when it comes back, it can't then change what was done because it no longer has that power to change that. Yeah, considering how SC has basically refused to take up the matters of 370 instead of focusing on frivolous contempt, how do we place relevance on interpretation of implied limitations by SC? And I just think the important thing is to remember is that the SC has the last word on constitutional issues because somebody has to. That's the way of things. That doesn't mean that the SC is the repository of all constitutional wisdom. So the SC may or may not accept these arguments. I think it's for all of you as citizens and as law students and as future lawyers to engage with them and see if you find them persuasive. I think it's for all of us to kind of engage with the Constitution on our own terms and see what it's trying to say and do, regardless of what the SC does or says in any specific case. Considering this is a really unique situation, what precedents or principles will the judges rely on to reach the judgment? Yeah, so I think exactly. It is a case like Keshavananda Bharati. It's a case like the ordinances case, where ultimately you need to go to first principles. The questions you have to ask yourselves are basically, what are the underlying principles of the Constitution, and how are they attracted in this case? And as I said here, in the first example I give, there is the principle of representative democracy that says that at all times there should be a elected body that is governing. That is one principle. The other principle is president's rule that the constitution expressly authorizes. And so the court has to say, like, at what point do we harmonize these two when they clash? And as I said, the UK Supreme Court's Miller judgment gives you a conceptual answer that you harmonize them by saying that neither should erase the other. So if we give president during president's rule complete unchecked power, then representative democracy has no meaning anymore. On the other hand, the president has to have some power during president's rule to govern. So we find that balancing principle by formulating the argument like this: the president has all the power that parliament or the elected body has during president's rule, up to the point at which the president's actions alter the fundamental character of the state or of the assembly. So that's where his or her power ends. And similarly with the Article 3 argument. So I think that it's perfectly possible for the court to formulate a precise legal principle that is drawn from these underlying values and ideas of the Constitution. So J&K will face the same tussle between the state and center like in Delhi. I think it's hard to say. I think there are. I think the call for statehood in J&K is kind of like a primary political demand. So I think it'll be more along those lines and less along this whole distribution of power argument that has basically stymied Delhi for the last 6 years. Yeah, I think when we read the whole provision, who should also look at the intent that was there initially in the making of the provision, because three of the most important subjects were given to the central what? Sorry, can you complete the question? Okay, I assume that the point is that India is an asymmetric federation, which is skewed towards the center, and therefore the design of the constitution is such that the center has more powers. That's completely correct, and I completely agree with that. And again, so the key issue here is that how do you draw the balance between the center having more powers and having residuary powers, and the fact that we are nonetheless a union of states and nonetheless a federal democracy, right? So it's like it's an asymmetric federalism, but it's still federalism. It's not a unitary state. And I think that therefore, in the Article 3 issue, the point is that the asymmetric powers of the center extend to the point at which it is not able to turn India into a unitary state. So that power it does not have. It has everything short of that, and that's where you draw that line for the Article 3 argument that respects the asymmetric federal character of the state while also respecting the fact that we are a federal and not a unitary state. Does SC have the power to establish status quo now? Yeah, it does. It's done it before. In the Uttarakhand case, in the Arunachal case, the SC has the power to strike down CO 272 and restore status quo ante as it was on August 4th, 2019. Some irreversible moves have been made on the issues of environment and clearances and stuff that probably you can't put back now. But technically and as a matter of constitutional law, it's perfectly capable of restoring status quo. So yeah. Will it be presented as a fait accompli before the court? I mean, in all likelihood, yes. But that doesn't mean the court has to accept the argument. In CO Order 272, Clause 2 of adds 4 to 367, mentioning that the state shall be construed as including references to the governor, not solely the governor. I completely agree. Like that's right. I should have clarified that. It's an inclusive definition. I don't think that alters the core of the argument, which is that the assembly no longer has the powers it used to have, and it can't get them back. So I think a follow-up question here: since the assembly was dissolved, how can the concurrence be achieved? Well, it was dissolved, but then the governor was in power, right? So effectively, it was the governor's concurrence that was taken. The same, like that was the whole argument. That's a different argument, but there's the whole argument of the state of hand here, because the same body took its own permission to accomplish this, because the assembly was in existence. So effectively, the governor was asking the governor for consent. So that obviously, is a bit of a problem, but that's a different issue, and I don't want to get, that's a very complex issue, and I don't want to get into that today. Is it likely that the ST will adjudicate on reorganization after elections in the UT, and even if it says that the reorganization is invalid, would it dismiss the LA of the UT? What is LA? Assembly. No, so if it says the reorganization is invalid, that's a good question actually. Yeah, I mean, like, if it says the dissolution is reorganization is invalid, then it would have to logically dismiss the LA, because that was conducted under the Reorganization Act. So all the actions there would have to go. So I think yes, it would have to dismiss the assembly, and it would have to effectively restore status quo ante as on August 4th, which would mean governor's rule / president's rule, and eventually fresh elections to the state, not to the UT. That's my guess, but I'm not entirely sure about that. What is the contrast between presidential order used in 370 and the amendment of the Constitution? Can at any point in time there be an amendment to this order under a constitutional amendment? Okay, that's two good questions there. Slightly off track, but I'll briefly answer them. So yeah, the Constitution has a number of these provisions that are implied amendments. So, for example, look at Article 4, Clause 2. Article 4 talks about laws made under Articles 2 and 3 to provide for amendment of the first and fourth schedules and supplemental and incidental and consequential matters. So that is when you are adding a new state, changing the state, the first schedule will change along with it. So Article 4, Subclause 2 says that no such law as aforesaid shall be deemed to be an amendment of the Constitution for the purpose of Article 368. So you have the, and you'll see this language is repeated a few times. So the Constitution has many such provisions where effectively you are amending the Constitution in a technical sense. You are changing the text of the Constitution, but the Constitution itself says that does not count, because it's allowing for a non-amending process to do that. So it's a constitutional legal fiction there that says that this will not be counted as an amendment. Technically, there is more of a case for that in 370, because you aren't amending the Constitution, you are amending the Constitution as applied to J&K. So there's a slight technical difference there. But again, the principle is the same. Can there be an amendment to the order under the constitutional amendment? So that's the thing. Both Article 370 and 368 start with a non-obstante clause. Both say notwithstanding anything else in this Constitution. And so both have effectively equal primacy in formal terms. So I think it's a really open question whether you can use the process under Article 368 to amend 370, and I don't know what the answer is. There are arguments on both sides on that issue.
If audience have any further questions, you can email Gautam. And thank you, Gautam, for joining us. Since last year, we were contacting you for this session. And I hope that when normalcy is restored, we will host you at our campus.
Yeah, I'm looking forward to seeing all of you in person as well.
Okay. Thank you. Thank you very much.
Thank you. Have a good day. Thank you. Bye.
Thank you.